Are you saying that if you move to the state of Florida, you buy a $5 million home, you've got to wait roughly 3.5 years before you can file bankruptcy?
You've got to wait a couple of years. Otherwise, they're required to use the laws of the state where you move from,
Okay.
or the federal exemptions to determine what you can have as homestead.
And so that if you're a resident of the state of Florida and you buy a $5 million home and you try and file bankruptcy and keep your $5 million home, that's where you've got to wait for 3.5 years roughly?
Well, you have to wait that 1,250 days to do that.
Hey, I know, I mean, there is another limitation on homestead here in bankruptcy here in the state of Florida, and that is that if you live within the city limits, you're limited as far as the size of the lot that your home is on. If you live outside the city limits, if you live in the county, then you can have, I think, like 160 acres.
In the county, it's 160 acres. Inside the city, it's up to half an acre.
So a half an acre is a pretty big residential lot, but there are some bigger lots, like over in Winter Park, for example. I remember you telling me one time about a case, a well-known person in Winter Park who wanted to file bankruptcy. They had a big house on a lake. Let's just say that their house sat on a lot that was 1 acre. They want to file bankruptcy. How does bankruptcy handle a mansion that's on 1 acre when you're only protected up to a half acre?
Well, they say that proportionally that half an acre is not protected. So you would take the entire value of the house, subtract out the mortgage, and that half would not be protected, but the other half would.
Okay, I want to get that. I didn't understand what you just told me, okay?
Okay.
He's got a mansion on a 1 acre piece of land in Winter Park. He files bankruptcy.
Right.
How does the court determine what of that 1 acre is protected?
You take you have the entire house appraised. So the value of the house is appraised.
And the land?
And yes, the house and the land.
Okay.
And then you subtract out the mortgage.
Okay, let's assume there's no mortgage on it. Don't get me confused.
Then it's only half.
Meaning you can't take the one half. You can't take say okay the half acre I want to protect. I want that half acre where the house sits and the driveway from the house to the road.
No, you cannot demarcate. And there was a famous case where that was pretty much put to rest, where you cannot just go and draw a line. In this case that we're talking about, what they did is they attempted to go into the backyard and put sort of like a helicopter pad, donut shape, in the middle of the backyard and said, okay, that's non-homestead property, and the rest of this property is homestead. And the court was very indignant and said, no, you can't do that. It's proportional. So what we do is you say one half is homestead exempt and the other half is non-exempt.
So what would happen in that situation if the court says, okay, here's a $5 million house, it sits on a 1 acre lot, therefore only $2.5 million is protected from bankruptcy? How would the court handle that? Would it require that the property be sold?
The trustee probably could force the sale of the property through a partition, or the debtors find a way to come up with the money to pay the trustee for the non-exempt 1/2 interest.